tried a case in Beaumont, Texas, involving the death of a 9-month-old infant who had been given an overdose of digitalis. And the child died of digitoxin toxicity. The problem with it was that children in damages, infants, do not experience mental anguish. There's no guideline that they start experiencing. They wake up on their 3rd birthday and say, this is really a rotten day. There's no guideline. They just say you can't recover from mental anguish as a child. So I was trying this case in 1971, and the court wouldn't give me, he said, I'll give you mental anguish submission if you want to, but you're going to get overturned on appeal. So I said, no, I'm good the way it is. So we tried the case. After the trial, the judge said, and this is the important part, this leads to the whole thing we're talking about. The judge said to me, Mr. Nations, you did a great job on your closing argument. And in doing so, you created a big problem for yourself and for me, because the jury is going to return a verdict of more damages than I'll be able to uphold. And I'm going to have to enter a remittiture. And it's a problem for you because you're going to have to explain to a jury why they don't recover the amount of damages that the jury awarded. And he was right. The jury came in, and then I talked him out of the remittiture, but they took it up to the Beaumont Court of Appeals, and they remitted it. And it brought home to me the significance, the extreme significance of something that I was aware that law schools don't do. Law schools do not teach us how to prove damages. They may tell us what recoverable damages are, but they don't tell us how to go about creating a body of proof or the significance of a body of evidence for damages. So I've taught damages in law school for 25 years, and so I want to talk to you about what I've learned from that. And I sort of developed my own paradigm for evaluation and proof of damages that I've been using for all those years. What we don't do, what we fail to do as lawyers, is understand the importance of availability concept. I've always called it the spotlight theory as far as lawyers are concerned. The jurors will focus in deliberation where the evidence was focused in trial. What we don't do, we save the damages for closing argument. I'm going to give up there and do exactly what I did in that case in 1971. I'm going to give a slam-bang closing argument. They're going to bring in damages, and it's going to get set aside because I did not make the proof. So I learned the hard way in that case that I had to have proof to back up everything I said. So let's talk about how do you go about using, what is availability? The availability has an unconscious mind appeal. It goes directly to the unconscious mind of your jurors. The more evidence that you produce, and I understand this, I'm not talking about repetition of the same evidence. I'm talking about redundancy of your theme on evidence. It's coming at damages evidence from every different direction. Lay testimony, expert testimony, documentary evidence, demonstrative evidence, a body of evidence. And if you create a body of evidence, this can lead to focus in the conscious mind as well. So you're hitting all parts of the brain that are going to be deciding how much money your client gets. The unconscious mind appeal, the availability, is extremely important to the majority of today's jurors because now what we're getting are mostly the millennials. There are 86 million millennials. There are 40 million Gen Xers, and there are 80 million boomers, but most of the boomers have figured out how to get out of jury duty by now. So we're trying cases to our Gen Xers. They are very, very, very much unconscious mind people. So let's take a look at this. How many squares do you see in this box, in the screen? Okay. There's 16. But are there really? Okay. Now, it says 16 because that's all the evidence I'm presenting to you. If you look at it further, if I bring more evidence, there are actually 18. If I bring you more evidence through the if I make available to you more evidence, there are really 22. I can make available further evidence that show that there are 26, 28, 30, 31, 32. So what I've actually done, now you see the availability, I made available to you 16, and then I kept adding what was available to you, and you saw that it actually doubled. That's what we have to do with damages. We have to make available evidence of damage. Arguments are fun. Evidence is hard, but you got to have both. So let's talk about how do we decide how to do that. How can you go about that? My position is that we should create a body of evidence that supports each individual element of damages. I'm going to go through the elements real fast because we know what they are, but I want to point out to you that the point that you need a separate body of evidence. You take physical pain and suffering. Now, we'll put that up on we'll get in our war room, we'll put up on the chalkboard, we'll put physical pain and suffering. And under that, we'll put every bit of evidence that we have, just on that one element. We put lay testimony. What witnesses do we have on physical pain and suffering, and what will they say? What is the amount, the quantity, and the quality of their evidence? Then we'll take documentary evidence. What documents do we have? Medical records that will substantiate an award for physical pain and suffering. What demonstrative evidence do we have that will support physical pain and suffering? And then we talk about creating additional demonstrative evidence, and we're going to talk about that substantially here shortly. But then we talk about, now, what expert witnesses do we have? So lay testimony, expert testimony, documentary evidence, and demonstrative evidence, and we put it all up on the board. Then we move on to the next element. The defense has a tendency to talk about pain and anguish as if it were one element of damage. There's all the difference in the world in physical pain and suffering and mental anguish. And you should make a concerted effort to separate those two. You should produce your evidence separately, and you should argue your damages separately. One argument for physical pain, a separate argument for each one of the elements of damage that you can support in a closing argument. So I'll give you an example of this. I handled a case many years ago, tragic case. Young couple on their honeymoon. They were driving along the border on the American side, just across from Mexico. There's a lot of open fields out there where they were harvesting crops. And they're driving along this 2-lane highway, and all of a sudden this harvester, they swing the equipment around just in time that it protrudes out into their lane, no time to react, and it took the roof right off the car. And the car went into a spin, and by the time it stopped, the young driver, who had been a medic in Vietnam, he was sitting there frozen like this. He couldn't move. He had no movement in anything. He's holding on to the steering wheel. He's got all kind of pain, but he's holding on to the steering wheel, and he can't move. Finally, he manages to get some movement in his right arm. Now, he's got all kinds of pain. He has 2 broken scapulae. He has a broken leg, and he is frozen in place. He thinks he obviously has a neck injury, but he thinks he's quadriplegic. That's mental anguish. That's mental anguish. He's got a broken leg. That's physical pain. But then he reaches up, and he knows not to try to move his head because he thinks he's got a broken neck. But instead, he reaches up and grabs his shirt with the only thing he can move, which is his hand, and he pulls himself around like this, his whole body around till he can see his wife, who's been decapitated. That's mental anguish. See the difference? So you need a body of proof on each one of those. Now, physical disfigurement, physical impairment, which is disability, bystander mental anguish, these are the elements that you can look into. Loss of society and companionship, loss of consortium. We have these as a checklist, and we use this checklist on every case, every personal injury case we get. We run it down the checklist, and you'll be surprised how often you find, whoops, I had forgotten about that. So, and the checklist is available in your paper. Loss of damage to wage earning capacity. I hear a lot that, well, he doesn't have any damage to wage earning capacity because he's making more money now than he was before he was injured. That's not the test. There's wage loss, but then there's wage earning capacity. So if he had a capacity to earn money before he was injured that he does not have now, something was injured that's reduced a capacity that he had to make money before, he has damage to wage earning capacity. Then there's wage loss. Then you go into medical expenses, pharmaceuticals. A lot of time you overlook pharmaceuticals. It's only $12 a week or whatever. Run that out over somebody that's going to have to take it for their entire life. Do a lifetime projection on pharmaceuticals. You'll be amazed at the amount of money it comes out to. Funeral expenses. And then you go into the other things. Personal property damage, cost of vehicle repairs, rental car, pre-impact terror is an element of damage, which we'll talk about. Loss of chance of survival in some states. Attorney's fees. I'm amazed at the number of times that lawyers fail to plead attorney's fees where they might be available. Now, this is not in personal injury necessarily, but I've done it in a lot of cases that involve federal legislation. There are so many federal statutes that provide for attorney's fees if you breach them. But we had a statute in Texas, Article 3.62 of the Insurance Code, that said if someone dies and they're insured and you don't pay off the insurance coverage, you get a 60-day notice on it. You give them 60 days. If they don't pay you in 60 days, you're entitled to your attorney's fees, an 18% penalty, plus attorney's fees, plus prejudgment interest and post-judgment interest. I defended over 100 of those cases. And in maybe 10 cases, the lawyers working for the forces of evil. Then in maybe 10 of those cases, about 10%, the lawyers actually pled for all that money that can drive a $100,000 policy up to $225,000 or $230,000. All they had to do was plead it. But so look for these things. You have your consumer protections, contractual damages, bad faith, pre- and post-judgment interest, and punitive damages. Now, a lot of that won't do you any good at all unless you can find the coverage. Always exhaust coverage. And here's a big tip for you. Carriers will lie about their coverage. Aren't you shocked? No, they will. No, I know you don't believe it, but they will. They will lie about their coverage. They will also defraud. They'll go further than lie. They will defraud about their coverage. So you depose, if you have any question about it, if you get damages far in excess of what they claim they have, you tell them you want to depose the underwriter. And it's an amazing thing. The other thing is, read the policy. Read the policy yourself. Don't take their word for anything, but it's the excess coverage is what they hide. You got the policy, but they'll hide excess coverage. So you pursue all coverage and don't take anyone's. I could do a whole speech right now on all the times that I've caught insurance companies lying about coverage, and we've discovered it. Take no one's word on coverage. We talked about your body of evidence, lay witnesses, expert witnesses, documentary evidence, and demonstrative evidence. Now, your lay witnesses, you want to find everyone, because this is the evidence. You want to find everyone who was present at the scene, especially neutrals who were present at the scene. Because neutrals, people that stopped to help, the Good Samaritans, people who are in the neighborhood who just happened to be around there, you want to find everybody who was at the scene, everybody whose name appears on the police report or on the EMT record, anybody that got a statement from at the scene, and you want to talk to everybody, and you want them to testify to what they witnessed at the scene of the physical pain and the mental anguish of your clients. A very good source, it's hard to lose on this one, the defendant was always at the scene. The other driver, always ask the defendant driver to describe the physical pain, to describe what did you see the plaintiff? Yes, what did the plaintiff look like? Tell us what Mr. Jones looked like. What was he experiencing? And if they try to downplay it, they look bad. If they tell the truth about it, if they describe all that pain, then you've got the best witness you can have on that, which is the other side. But the one I had where the fellow had the fender of the car impaled into his leg, it was an 18-wheeler. And this is what you'll get from 18-wheeler drivers. I asked the driver, I said, now, did you call when were you knocked unconscious? No, I wasn't. tell us, did you call 911 to report this when it happened? He said, no. I said, well, did you get out of the car immediately to go help him? He said, no. I said, did you make another phone call? Is that why you didn't get out of the car or your truck? And he said, yeah. I said, well, who did you call? The same people they're always instructed to call. I called our investigator. I called our investigative team so that they could dispatch our investigative team to the scene immediately. So your immediate response was not to call 911 to help the man. And he's looking down. He could see from his windshield. He could see through his windshield. He could see the plaintiff. I said, so you made no effort to call to get. You could see. Was he in pain? And was he? Tell us what he was suffering. He said, well, you know, he looked okay. Okay. Did you ever get down and go down? No. Did you witness them take him? Yeah. And so then I had him describe how they let him describe the whole process of how they had to go through and how they extricated him and so forth. Okay. You lay witnesses. You want family and friends who, and the person we use the least, incidentally, the person we use the least is the plaintiff. You don't want the plaintiff to be talking about their pain and suffering unless there's no other way to prove it. But you heard Eric talk about how the dumbest thing is they fail to do this and they fail to do that. You're right, obviously. But you don't say the doctor failed to do this. You say the doctor chose to do this. And you present it as a positive. And you present it as a positive because that way it resonates with the unconscious mind. The unconscious mind sorts out positive and negative and just sorts the negatives to the side, does not register negative. So if you want to communicate with the unconscious mind, you communicate in the positive. So what you're doing here is you want the family and friends to be the one that will be complaining about what he can no longer do that he could do before, the physical pain, the mental anguish. All these people are testifying. What the plaintiff testifies about is not what's wrong with him. It's not that I'm hurting here and I'm hurting here and I can't do this. What you want him to testify to is his courage. He wants to be presenting a position of courage. Here's what I'm doing now. Well, why are you doing that? Well, because I can't walk on this leg, or I can't get used to this. But it's not, again, it's just pure courage on his part. In my opinion, that's the best way you can project a plaintiff, is courage. Everybody else is projected. Everybody else proves up the pain and suffering, mental anguish, because you've got to overcome the jury bias where they don't believe the plaintiffs, and you need to create so you don't want a whining plaintiff. That's the worst thing you can have on the stand, is a whining plaintiff. But it's hard for the defense to deal with a plaintiff who is just simply telling the story of his courage, the courage that was involved. Now, you want to look for your healthcare providers as witnesses, your rehab team, your life care planners. Then on your documentary and demonstrative evidence, here's how we approach it. Number one, what's available? Everything that's available in terms of documentary evidence for each element of damage, anything we can find. Second, how can it be simplified? So that make sure, as Albert Einstein said, make everything as simple as possible and no simpler. But if it got a complicated situation, you don't have to live with it. How can it be simplified to bring it down to a jury level? You just ask yourself, could George Bush understand this? It's a simple test. How can it be enhanced? All right, that's an important question. And it's a simple example. You take an x-ray and you turn it into a positive and mount it on a board and blow it up, put it up, and now they can look at it. They don't have to look through an x-ray machine. The next thing is, when you put all this evidence, you got your board filled up now. You're all around the room and you've got everything, every element of damage up there. You've got who can testify to it. You got what documents do you have to support it. You got what demonstrative evidence do you have to support it. So now you've got everything covered. And now you can stand there and look around, look at the board, and you can see, where are the holes in my evidence? Wait, I'm short over here. What can I do to fill in this hole in my evidence on this element of damage? So then, what can be created? And what can be created is what I just showed you. Everything you just saw in that whole presentation was created except the picture of the vehicle. So, and that's particularly important. Now, reference points. In the Trilogy of Persuasion, I like to use a reference point on damages. And there's a big debate about whether you should mention damages and put a number on damages in your opening statement or not. I mean, not an opening statement, but on voir dire examination. But here's what I like to do. If you can get a supplemental juror questionnaire, then you put the question in supplemental juror questionnaire, and you can state it as you saw Lisa do, and I learned all this stuff from Lisa. You can use a scaled question, and your question can either be a statement of, if the evidence supports it, I can award damages of $1 million, $10 million, or whatever you want your reference point number to be, because this is where they hear the number for the first time, is on the questionnaire. If the evidence supports it, I can award $1 million. I can award $10 million for a personal injury or a wrongful death, whatever it is. Scale it from 1 to 10. Or you can scale it the other way. Regardless of the evidence, I could never award $10 million for a personal injury. Now, that's the one you really want. Why? Because that'll disqualify a juror. If they answer that they could not, then they've just disqualified themselves, because it says regardless of the evidence. I could never do it. Then that's how you get your tort. That's one way you get the tort reformers off, unless they've been trained for it. Now, what I like to do on opening statement, and whether you do it on voir dire or not depends on lots of things, and I leave voir dire to my expert over here. I was asked one time on voir dire, Your Honor, we'd like to know what Mr. Nations is suing for. And I said, this case involves millions and millions of dollars. That's all I said on voir dire. And the defense lawyer stood up and said, Your Honor, we have a right to know what Mr. Nations is suing for. And the judge said, Mr. Nations? I said, millions and millions of dollars, Your Honor. She said, fine, you may proceed. So I never like to put a figure. Don't put a figure on it, because you never know what's going to happen to the evidence. Now, one of the things I like to do in opening, and I think this is very important, as opposed to everything else I've told you, in opening statement, I like to put up what I call road signs, or signposts. I explain to them, as we all do, that you have a power that the judge doesn't have. You are the sole judges of the amount of money that can be used to compensate, even begin to compensate, for the damages suffered by the plaintiff in this case. You're going to be called upon, and you're going to hear me put on evidence. And I'm going to call witnesses who are going to talk about the physical pain that Mr. Jones suffered, the mental anguish that Mr. Jones suffered. But I want to tell you now that is because I have the burden of proving that to you, and you have the important task of putting a dollar value on those elements of pain and suffering, mental anguish, physical disability, whatever. So when I'm putting that evidence on, it's to assist you in arriving at that number. Now, as you then go through the evidence, and you put a witness on, and you have the nurse up there and say, oh, they're talking about him being hospitalized. Now you say, now, Nurse Jones, let's turn to the element of physical pain and suffering. So you give them a signpost. You've told them, we're going to do this. It's the military method of teaching. You tell them what you're going to tell them, then you tell them, then you tell them what you told them. So you've told them what you're going to tell them. I'm going to prove this for you. Now, leading into the question, you say, now let's turn to evidence of your testimony about physical pain and suffering, or mental anguish, or whatever it is, so that they understand why and when and why you're doing that. As far as summation is concerned, damages and summation, you save the emotional appeal for the second half, for your second opportunity. I put on just enough evidence about damages in my opening part to qualify, but then I save my damages for closing, and especially the emotional part, so that they do not have the opportunity to reply to it. Let's talk about some real quick principles. And this is important too, especially now with our Gen X, with our millennials again. In communicating your message about damages or anything else, your verbal communication is only 8% of the delivery of your message. I'm not saying words are not important, they're extremely important, but they're only 8% of the delivery of your message. The vocal communication is 37% of the delivery of your message. And nonverbal communication is 55% of the delivery of your message. So it's very, very important. The vocal, the reason it's so important is because that's where they're reading your sincerity. If you are just standing up there going through the motions and you don't believe in your case, it's what Jerry was talking about this morning with the poor defense counsel who have to come in there and meet they come in and meet their client for 30 minutes before they have to go out and try to keep them out of jail. Well, they're going through the motions. It's unfortunate, but they are. So if you don't believe in your case, then get the hell out of the way and let somebody try your case that does believe in it, because there's where they'll nail you. They'll nail you on the vocal, because that's what carries your voice, and your eye contact is what carries sincerity. That's your belief in the case. And if you don't believe in it, why should they? So those are important. But what's equally important is what Milton Erickson taught us, the importance of the synthesis between verbal, nonverbal, and vocal communication. If you are saying one thing and your nonverbal communication with your client and with them about your client is saying something else, then the nonverbal will prevail every single time. Every single time. It's 7 times as important in delivery of the message. And what happens if you're given a verbal message and a different nonverbal message, then they realize that your verbal message was what? It's a lie. So if your verbal message is a lie, your trustworthiness just went down the tube. You lose your trustworthiness. You've lost your case unless the defense lawyer is even more untrustworthy than you are, which he always is, but they may not recognize it. Let me tell you very quickly about the unconscious mind appeal and the conscious mind appeal. I've been talking about this, as Eric said, I've been talking about this for 30, 35 years. Daniel Kahneman just wrote this incredible book, which is all about what he calls System 1 and System 2. He calls it fast thinking. This is thinking fast and slow. The man got the Nobel Prize in economics for the work that's manifest in this book. He knows a little something about communication. We take it and apply it to trials. What he calls slow thinking is the conscious mind appeal. What he calls fast thinking, fast thinking just means you get it right away. You don't process it through your conscious mind. So he has brilliant data in there. The conscious mind appeal, and this is how you reach people through the conscious mind, is the hard evidence, the court's charge, your visual evidence, which is both conscious and unconscious, and your supported numbers, and the word is supported. You should have a reason. Come up with one, whatever it takes. Think about it in advance. Have a reason for your number. Nothing falls flatter than, well, with respect to physical pain and mental anguish, I think that should be $500,000. Why not $500 million? Have a reason. Have a reason for any, just like I think in the McDonald's case, the damages were based on 1 day of coffee sales by McDonald's in all their places around the world. But have a reason for your numbers. The unconscious mind is direct communication with the portion of the brain where fast decisions are made. This is the absolute definition of your millennials. They don't think, they work so fast, if you don't get their attention and hold it immediately, if you put up enough quantum of evidence, and this is what I'm talking about availability, the difference between 16 and 32. You put enough evidence in, not repetition. Kahneman acknowledges, and we've heard juries say it over and over and over, that they hate repetition because it bores them. They say things like, well, obviously that lawyer thinks I'm stupid because they think I didn't get it the first 8 times they said it. So they had to say it a 9th time. There's a big difference between repetition and redundancy. Redundancy is what we should do. Redundancy is where you come at the same theme from every different direction. You come at it from the documentary evidence, the demonstrative evidence, lay testimony, and expert testimony. It's all accumulative evidence on the same theme, but just not repetition of the same words, like Fox News, the echo chamber. That's what they're all about. Okay, so the other thing about the unconscious mind is this is the important part of the brain, because this is where processing takes place. I mean, it's where it goes straight through without processing. Is you tell your story in the present tense because the unconscious mind does not process negative. It doesn't process negatives, and it doesn't process things in the future, and it doesn't process things in the past. If you talk about the present, or if it's happening in the present, the unconscious mind will process it. So that's why you tell the story as if you're there, and you do it in terms of, all right, let's come back now with me now as we visit this scene. What we see, and you're tell the whole story in that fashion. You avoid negatives. That's why the unconscious mind does not process negatives. That's why you don't say the doctor failed to do this. You say the doctor chose to do this. It's because of unconscious mind communication. Rhetorical devices. Rhetorical devices, y'all, are extremely important because they communicate directly with the unconscious mind. A metaphor is the power of a metaphor is so hard to overestimate. For this reason, give you an example. The case I told you that I tried in 1971 with the child. This child had digitoxin toxicity, and so which led to heart failure. They had to defibrillate the child 15 times, which means putting the paddles on them and sending an electric shock through the heart until the heart stops beating. Defibrillation. But defibrillation, the word defibrillation fails to, as Aristotle said, execute the required level of emotion. So if you want to know what your metaphors are that will resonate, you do what I did. I had this big discussion with my doctor as we were driving over to Beaumont, actually, for him to testify. I said, okay, we got to think about this. Defibrillation doesn't get there. This was back before we started using focus groups to figure all this out. I said, but describe for me exactly what's happening. He said, well, you put the heart is fibrillating, which just means squirming like a can of worms, and then you put an electric shock through the heart with sufficient force to stop the heart from beating completely. And then the next signal from the brain comes and it starts the heart back to a normal. It's rebooting the heart, basically. And I said, okay, answer this question for me. It's defibrillation is just like, and he thought about it for a moment. He said, well, it's just like electrocution. Same thing we do to people in death row, except we keep the thing going until there's no new signal from the brain. So now, I said, you give that metaphor and give that analogy on the stand when you're asked about it by the defense lawyer. At any opportunity. If he asks you your name, say, well, let me explain to you what defibrillation is. So now we're dealing with 15 electrocutions of a 9-month-old child, and that's what drove the damages up so high that it had to be a remitter. I guarantee you that one thing drove the damages so high it got a remitter. Okay, so you want to find metaphors, analogies. Rule of 3 is a rhetorical device. It's a whole long list of things that we use. Okay, so you want to seek similarities between yourself and the jury. It's just like Lisa talked about Oprah. What are they like? Looking at their intake information, what are they like? They all like Oprah, so you like Oprah too. Seek similarities. All right. Sequencing is extremely important. with respect to damages. I personally think that you have to, or at least you should, prove your liability first. And then there's a thing called the Zeigarnik effect. You prove your liability first, and then you have to talk about your damages some, but then you let the jury discover on its own the severity of your damages. I never stood up in front of a jury in my life and said on voir dire examination, ladies and gentlemen, this is a medical malpractice case which has caused this poor plaintiff to have permanent, irreversible brain damage. No. You start out by saying, this is a case involving a severe head injury. And then as you move along through the proof, then it gets a little stronger in the language, but only after the doctor takes the stand and answers the question, doctor, is there anything that can be done to cure this? No. How long do you anticipate that? Well, this is irreversible. This is something this patient will live with for the rest of their life. When the doctor says it's irreversible brain damage, now you can say it, but you don't come in and feed them that because it's hard. It's the expectations are too high because they may get all kind of images in their mind. So start out with lower expectations, and then the Zeigarnik effect is this. It is that jurors, we all, not just jurors, but we all cling to tenaciously that which we discover on our own. So what we do is we help the jurors discover on their own how severe this injury is. And then once they discover it on their own, it becomes their discovery. Then the confirmation bias kicks into play, which means that they will then begin seeking evidence that confirms their belief. Once they discover that they believe that this is a severe injury, then they'll start looking for evidence that confirms their own belief. And then it really gets good. Availability is, we're back to where we started. This is all about the availability, making available actual evidence of every single element of damage for which you're asking the jury to give you money. I think that's, and then I'll leave you, as I frequently do, with my favorite quote from Shakespeare. The first thing we do, let's kill all the lawyers. Because those of us who actually read the Bard rather than the Cliff Notes in college know that those words are spoken by Dick the Butcher, who was a follower of Jack Cade, who was an anarchist seeking to overthrow the established order in society and put anarchy in its place. So what Shakespeare is saying through Dick the Butcher is, if you want to establish anarchy and do away with the established order in society, the first thing you have to do is kill all the lawyers. So it's truly a great compliment to the bar from Shakespeare. And so he's right. And keep this in mind. Two things you need to think about. One, always maintain your own personal pride of what you do as a lawyer, and maintain the pride of the profession as a whole, what everybody in the profession does as lawyers, because we are, in fact, the frontline defenders of democracy in this country. And as Jerry was pointing out this morning, we're it. So let's so conduct ourselves that 1,000 years from now, the tort reformers and the hard-nosed advocates and the corporations and the Bushes will still be saying, the first thing we do, let's kill all the lawyers. Thank you very much.